Contracts 1 General Principles revised in English language. Present topic for discussion is lawful object or legality of object. This lawful object or legality of object is one of the essential elements or ingredients of a valid contract. Section 2H of the Indian Contract Act 1872 enunciates that an agreement enforceable by law is a contract. An agreement to be valid and enforceable, it must contain some essential conditions as laid down under Section 10 of the Indian Contract Act. As per Section 10 of the Indian Contract Act, an agreement must be constituted or constructed by offer and acceptance under 2A, 2B respectively, lawful consideration 2D, capacity of parties or competent of parties as prescribed by Section 11 and 12 of Indian Contract Act, free consent as enshrined in Section 14 subject to flaws in consent under Section 15 to 22 of the Act. Finally, Section 23, yes, that is, the object of the agreement must be lawful. It must not be unlawful. This is subject, that means it should not be attracted by any principles, any concepts opposed to public policy as laid down under Section 26 to 30 of the Contract Act. In addition to that, there are three more issues on public policy, namely alien enemy and criminal conspiracy under Section 120A and 120B of the Indian Penal Code. Dear student friends, today I will take up this chapter, lawful object or legality of object. In first 15 minutes, I will give the summary or synopsis of the entire chapter. Those who can't afford their time, patience beyond 15 minutes or 20 minutes can stop it. They can have some idea. It may be useful for examination also. Those who can afford half an hour more can extend their attention towards my detailed lecture. In case any residual part of time is there of 5 to 10 minutes, I will give you some tips to educate you to be successful in examination and career. If you find it necessary, you can watch my lecture till end of my lecture. Otherwise, you can stop your video as and when you require. In first instance, I wish to enlighten in brief the entire chapter, lawful object or legality of object. Just let me take just 1 minute to pray God. Pay homage to my reverend parents, late Rega Apparao and late Srimati Kamdaratnam, and my wife Mrs. Baliwada Rega Tirumala Gauri. Let me express my deep sense of gratitude to my godfathers who are instrumental for my growth and development. Let me express my heartfelt thanks to all the authors and publishers of textbooks and articles, research papers in internet respectively, whose works I make use of for delivering these lectures. And finally, I deem it as a duty, honor to express my deep sense of gratitude to my student friends who are instrumental for what I am now. I wish to express my heartfelt thanks to my student friends for increasing my subscription to nearly 10,000. More than 909,300 subscribers are there, and very few. This gap will be completed very shortly. Thanks for your cooperation. At the same time, if you watch, I can have more inspiration to deliver more and more lectures. However, despite my deep inclination to upload lectures very quickly, my health is giving some trouble due to simple problems of cold and cough due to heavy rains for the last 2 months. Now, let me take up the topic. Legality of object or lawful object is one of the essential conditions as laid down under section 10 of the Indian Contract Act. So a contract to be, an agreement to be valid, it will become a valid contract and it will be enforceable. So section 23 of the Indian Contract Act says that an agreement entered into between the parties must have lawful object. The object of the agreement must be lawful. And section 23 says that any agreement entered into without unlawful consideration and unlawful object is void. The conditions envisaged under section 10, namely offer, acceptance, competence of parties, legality of object, free consent, all except free consent, if any condition is violated or infringed or absent, that contract will be rendered void and unenforceable. If free consent is absent, then the contract is voidable. Means if the aggrieved party challenges before the court of law, it will be declared void by the court. If the aggrieved party does not challenge before court of law and keeps quiet, that contract will remain valid. So, except 14 renders the contract voidable. All the other conditions, valid offer, valid acceptance, legality of object, all lawful object, all lawful consideration, all will render the contract void if they are absent. Now, so according to section 23 of the Indian Contract Act, any agreement with unlawful object or unlawful consideration is void. First, unlawful consideration. What is lawful consideration? What is unlawful consideration? What is the position? I explained in detail in consideration chapter. You may refer. Consideration, anyway, I have to repeat in a few lines. Unlawful consideration means something in return. In a contract of sale, money becomes consideration to seller. Money becomes consideration to seller. House becomes consideration to the buyer. In a marriage, bride becomes consideration to bridegroom. Bridegroom becomes consideration to the bride. So this is the position. Consideration means something in return. If consideration is not there, if any contract is entered without consideration, that becomes a gift. I explained in detail gift in Transfer of Property Act, in respect of which deals with transfer of immovable properties between two living persons. Now, coming to the point, unlawful if parties enter into an agreement with unlawful consideration. For example, you give my medical seat to my son through back door without merit. That consideration is unlawful. I will give you 1 lakh. You go and break the head of somebody. That is unlawful. I will give you 5 lakhs. You go and kill somebody. These are that consideration is unlawful consideration. That is unlawful, illegal, and different aspects I will explain in due course. That is, the consideration must be lawful. The consideration must be lawful. Suppose a government employee must discharge his duty for any employee, government or any employee or any person who extends service must do it for lawful remuneration. He should not do the job for bribe. So it becomes that bribe is unlawful consideration. So like this, unlawful consideration should not be there. Next, most important thing is unlawful object. Unlawful object means when a person wants to enter into do some job, the object must be good. The object must be lawful. That object, the purpose of the contract should not cause any injury or damage to anybody. A man may start normal business. A man should not start drugs business, prostitution business if it is prohibited by the state. So, suppose a woman may reside in a locality for leading life with matrimonial life with legally wedded husband. A woman is not allowed to live in a residential quality for prostitution. So, Kaushalya's case in constitutional law I explained in detail. So, this is why when two parties want to enter into a contract, the object or purpose of the contract must be lawful. It must be for lawful consideration. Section 23 explains in negative sense any agreement with unlawful consideration or unlawful object is void. But in other words, any contract is said to be valid if the consideration is lawful, if the agreement is the object of the agreement is lawful. Now, sometimes when the agreement becomes unlawful, when the object of the agreement becomes unlawful, if an agreement is the object of an agreement is said to be unlawful, if it is not entertained, it is not entertained by the society, if it is not accepted, it is not allowed by the state, if it is not acknowledged by the members of the public in general, so that object becomes unlawful object. The object to be unlawful, it is to be opposed to, it must be opposed to public policy. So there are some sections, section 26 to 30, these 5 sections except 29 are the section that speak about principles opposed to public policy. So section 29, uncertainty of the agreement. Next, agreement with alien enemy. And next, criminal conspiracy. These are the criminal conspiracy also is opposed to public policy. So what are these? See, these 5 sections and 7 sections, what they discuss, what they contain, we have to discuss in brief now, and I will give you idea of these 7 points in brief and then proceed to in detail. According to section 26, principles opposed to public policy. A contract or agreement is said to be opposed to public policy if the agreement is in restraint of marriage. Section 26. If the agreement is in restraint of trade. Section 27. If the agreement is in restraint of law or legal proceedings. Section 29. If the contents of the agreements are not clear, uncertain, confusing. Section 29. If the agreement relates to wagering agreement, bet. Section 30. In addition to these 5 sections under section 26 to 30, there are 2 more points. Agreement with alien enemy. So agreement with insolvent or bracket also can be added. And finally, a criminal conspiracy. In agreement to commit a crime. Under section 120A and 120B of Indian Penal Code. These are these 7 aspects are those which are considered as opposite to public policy. If any of 7 of these is present in an agreement, that agreement is treated as opposed to public policy, and that agreement is entered with for unlawful object. I explain these 7 points in brief and then go to detail. First one is 26. Agreement in restraint of marriage. When two parties want to enter into an agreement, they with reference to marriage, that agreement should not be against any matrimonial rights. When two persons get married, marriage is nucleus of family life. It is most auspicious ceremony in family life. By marriage, after the solemnization of marriage, the parties to the marriage, wife and husband, are conferred some rights by the state. They can have some. They are provided with some rights and obligations. These rights and obligations must be discharged mutually by the matrimonial parties, that is husband and wife. So that is why any party out of need, necessity or inevitable condition, if a man or woman gives an agreement against the infringing their, violating their, curtailing their matrimonial right, such agreement is not valid. I give you an example. Suppose a poor woman is there. Her parents are poor, they can't afford to get her married. One man is there, some rich man or above middle class man. He tells that, I want to marry you, provided one condition is there. You should enter into an agreement. You should enter into an agreement. I get married, we can continue our matrimonial home for some time. In case I don't like you, I leave you and get remarried to somebody. He may say. To that effect, in case I leave you, you should not file any case for any matrimonial right. On that, so this woman, out of poverty, if she gives agreement, she will get married. She can enjoy matrimonial life for some time. If she can't give such agreement, she will remain as unmarried. So, on that inevitable conditions, that woman gives an agreement. Okay, you may marry me. After you may leave me at any time, for which I won't file any case against you for matrimonial relief. Then the marriage is solemnized. After some time, this husband left her. Now, that agreement, she can file a case against husband for maintenance under various respective branches of law available to her. She can file a case against husband for restitution of conjugal rights. My husband should come back and stay with me. She can file a case, my husband is giving me trouble, I want to go out, under judicial separation or divorce by mutual consent. She can file a case against him for maintenance under various provisions available to her. That husband, in such case, when she files a case against husband for any matrimonial remedy, the husband should not say at the time of marriage you come to an agreement not to challenge for anything. He should not say, he is not allowed to say. So any agreement given against the matrimonial rights that infringes matrimonial tie or matrimonial rights, that agreement is void. So in this Catherine versus Pierce versus Catherine, one case is there. In that case, one woman, husband, one boy promises to girl to marry. I will marry you. I don't marry any other. In case I marry other, I will give you 2,000 pounds. When the matter was challenged, the court said that such agreements are void. This is about 26. Another thing, one more thing is, suppose a man enters into an agreement. You need not, though you don't marry my daughter, you should not marry the daughter of my friend, my neighbor. You are relieving my daughter and getting married to neighbor's daughter. I feel some insult in the society. So if you don't marry her, I will give you 5 lakhs. Okay, sir, depending on your promise, I will give. I don't marry her. I did not marry her, give 5 lakhs. So if the case is challenged, it is not enforceable. This is partial restraint of marriage. Suppose if you remain unmarried and don't marry any girl, so I will give you 10 lakhs. Okay, that is also full restraint. This is the thing. Suppose I am an employer. I have an employee, that is a manager, is doing work very sincerely. I tell my employee, manager, don't, if you remain unmarried till 35 years or 40 years, do go sincerely service, I will give you promotions and other business, other fringe benefits. That is partial restraint. Suppose if you remain unmarried and serve my organization, I will give you many promotions and I will make you partner and other fringe benefit. That is permanent restraint. Whether it is a temporary restraint or permanent restraint, that is void. That agreement is void. So this is with reference to matrimonial issue. Agreement in restraint of marriage is void. So yeah, see me, marriage contracts, marriage brokerage contracts are there. Marriage contract means two parties may enter into a contract for legitimate purposes and legal purposes. If the contract is entered into for unlawful purpose, that contract is void. Suppose a boy may get ready to get married to a girl, and okay, I'm engineering graduate, I want to do MS in America, and after marriage, if possible, I will take you, otherwise I don't take. Some arrangements for growth development. Now I am IPS, I want to appear for IAS again, and now I am in group service, I want development, I should go for some legitimate legal things. Contract may be there, such contracts are valid. So price of the contract is marriage, except boy is price to girl, consideration to girl, girl is consideration to boy. So there should not be any dowry, there should not be any bride price. That is Varakatnam or Skanya Sulkam in language. So they are strictly prohibited. So this is the issues with reference to marriage. This topic is also general discussion, it is okay. Now next agreement in restraint of trade, section 26 speaks about an agreement in restraint of marriage is void. Now second point is an agreement in restraint of trade. So there are crores of professions. The ultimate object is livelihood. There are 1 crore professions or crores of profession. The ultimate object of any profession is to get the livelihood and survival of the life. So that is why every individual in the society is provided with absolute liberty to take up any trade, business, profession of his choice. Any agreement entered into curtailing, infringing, violating the fundamental right of his trade and profession, that agreement is void. That is why section 27 of the section 27 of the Indian Contract Act 1872 enunciates that any agreement entered into in restraint of trade is void. Restraint of trade is void. So this is the position. Suppose the law laid down under this agreement in restraint of trade is laid down in Nordenfeld versus Maxim Nordenfeld Gunpowder Ammunition Company Limited. These details I will take up in the detailed class. So here agreement means for a temporary, simply I am telling you. Suppose the article 19(1)(g) of Indian Contract Act also lays down that article 19(1)(g), there are so many freedoms, fundamental freedoms, they are acknowledged as fundamental rights. Article 19(1)(g) I explained in detail in lecture in the constitution law. According to a right to trade, profession, business is a fundamental right guaranteed under article 19 clause 1 subclause G of the Indian Constitution. Clause 6 contains some reasonable restrictions on the trade and commerce. So this suppose I am doing some business with good profit, just like a grammar school case, and opposite to me another man is doing some business, Suppose I told that man, if you in this small locality two same businesses are not good, you close your business and shift to some comfortable place where there is no same business house. If you do like this, I will give you 5 lakhs. Relying on my word that my opponent closed his business, went to another place. Subsequently, I did not give him money. If he files a case, the court says that any agreement in restraint of trade is void and not enforceable. So this is the detailed information with the exceptions I will take up in there are some exceptions are there: goodwill, trade combinations, some three provisions under the Partnership Act, and other points are there. These points I will explain in goodwill, trade combinations, Partnership Act, and other things. These are the some exceptions. Means some agreement, service matters. So in some cases, in some professions, agreements in restraint of trade, agreements violating, infringing, taking over the fundamental right, that is freedom to trade, can be entered into in 5 exceptional cases. This is 27 is over. Section 28. Any agreement in restraint of legal proceedings or law is void. Legal proceedings or law is void. So any judgment is given as per the violating the legal proceeding, if any agreement is entered, that is void. Any agreement is entered violating, outweighing any law, legislation, provision of law, that also is void. So basically in administrative law, I told you, in constitutional law also, the constitutional law is the law of the land, is the leader of the land, national law. So any law passed by the parliament, that is central legislature or central law, must be according to the provisions of the constitution. Any law passed by the parliament on any subject should not infringe, should not be inconsistent with any provision of the constitution. If it is so, it is unconstitutional as laid down under section 13, clause 1, clause 2, pre-constitutional laws, post-constitutional. These aspects I explained in detail in constitution. That is, so the central law must be as per the in strict adherence to constitutional law. If state law, states passed law under delegated legislative power, these laws passed by state governments must be in consonance with central law and constitutional law. Any local bodies, companies, corporations, and other local organizations pass any laws, personal laws, special laws, service matters and others, these laws must be in consonance with, according to state law, central law and constitutional law. If any point is inconsistent, contrary to any upper superior law, that law is declared invalid or void or unconstitutional. So accordingly, so any agreement, if two parties enter into any agreement, they must enter into any agreement as per the provisions of law. If contract agreement is entered as per provisions of contract, sale of purchase of movable property as per Sale of Goods Act, a sale, gift, mortgage contract is entered as per Transfer Property Act. If a marriage is entered into Hindu law, personal law, Hindu means Hindu personal law, Muslim means Muslim personal law. As per that, the marriage contract should be entered into. So, if any marriage entered into violating the principles of law, that agreement is void. That agreement is void. So, any agreement entered against the principles of law, laws of the land, that agreement is void. Suppose if mortgage agreement is entered according to TP Act, if sale of goods contract is entered as per Sale of Goods Act, suppose the agreement is entered between publisher and author, it should be according to Copyrights Act. So normally the provisions of Copyrights Act are in favor of the author, but practically the agreement entered into between author and publisher is mostly in favor of the publisher only. If such can, otherwise the publisher will not give an opportunity for author to write the books. There may be so many personal understandings. In case the agreement with author and publisher is entered into Violating the principles of Copyright Act, that agreement in the event of dispute between the parties, if the agree party approaches the court, that agreement will not be valid. That will be declared invalid. So that is the position. So any agreement entered violating the principles of law, it is void. Next, 28, agreement in restraint of judicial proceedings or agreement in restraint of law is over. Next one is agreement relating section 26 over agreement in restraint of marriage, 27 in restraint of trade, 28 in restraint of law or legal proceedings, 29 relates to general provisions. I explained in offer and acceptance and also in contract act, elements of contract. A contract is to be valid and enforceable, it must be clear. The contents of the contract must be clear. The contents of offer and acceptance must be clear. If the contents of the contract or offer or acceptance are not clear, it is uncertain, that contract is void. That contract is void. There must be consensus item. The offer must be as per the prescribed procedure. The acceptance must be as per the prescribed procedure. The offer should be one, accept should be one, should not be there. When the person makes offer, it must be clear. It must be clearly understandable by the acceptor. Suppose A tells over telephone to be a oil merchant, send 10 tins of oil. So he should specifically mention whether it is ginger oil, coconut oil, groundnut oil, or sunflower oil, or palm oil. He should mention. So all times he is taking sunflower oil. That is that it contains. It is implied. Clarity is there. Impliedly, the terms of the contract offer is certain. Suppose simply in Taylor versus Fortington case also, I want to take your house for rent if the drawing rooms are fully decorated as per present style. That case is there. So what is present style? What is your taste? How it is to be decorated? The landlord cannot understand. So the offer of the tenant is not clear. So the terms of the contract, the terms of the agreement must be clear. They must be clear. Just like A has two houses, one is 50 lakhs and the other is 75 lakhs. X is 50 lakhs, Y is 75 lakhs. B thinks that in the mind of A, house X worth of 50 lakhs. In the mind of B, the house is Y worth of 75 lakhs. He readily agrees, thinking that 75 lakh house is we are getting for 50 lakhs. But when the contract is to be implemented, performed, there will be conflict of mind. Identity of mind is not there. So the contract will be rendered. So the terms of the contract must be clear and certain as per section 29 of the Indian Contract Act. Now next section is section 30. Section 30, that is wagering contract. Wagering contract. So according to the word wager means bet. Wagering contract is nothing but betting contract. Betting contract. It's a contract of aleatory. It is a contract of aleatory in which there are equal chances of loss and gain. It is equal chances of loss and gain. The betting contracts are the contract of wager. A contract of wager is a bet. A contract of wager is not valid. It is void. It is void. It is a contract in which the parties express two opposite views as to happening of some future uncertain event. If the event happens, one will get. If the event doesn't happen, other will get. So that is even general insurance contract, accident insurance contracts also, they are wagering contracts. Wagering contracts. So in accident insurance, insurance company will give money if the if the person issued died of accident only. In medical insurance, if the insured gets disease, hospitalized, then only it will. If he is healthy, he won't get anything. So, as to the future unforeseen event, the person who takes property insurance, general insurance, inland insurance, goods insurance, all these are wagering contracts. They are permitted subject to license. Any act, any illegal activity can be legalized by issuing license. License. Suppose consumption of alcoholic drinks may be illegal. If the government gives license, it will be legalized. Some countries prostitution is legalized by license given by the state. So, an illegal act can be legalized with the license issued by the state. So, like this, the contract of wager is a betting contract. Suppose anybody makes a bet, India will win or Pakistan will, India will win or Saudi, West Indies will win, like this. Those betting contracts are wagering contracts. They are void. So that is why lottery tickets, sale of lottery tickets also is wagering contract, is void. If some states are passed by legislation gave license for conduct of lotteries, some states abolished the lotteries. So it depends upon the state to issue. It is a state matter. The state concerned will take necessary action to that. So the contract of wager, a wagering contract, and this contract, the contract of wager is not defined in Section 30 of the Indian Contract Act, but Sir William Anson defined the contract, and Hawkins J. in Carlyle versus Carbolic Smokeball Company has given his definition. The contract of wager and contingent contract, these two aspects I will explain in detail in the next lecture. This is separate chapter. Now with this, section 26 to 30, various aspects have been completed. And the next thing is, next topic, there are two other issues opposed to public policy. Alien enemy means one citizen in one country, another citizen in another country can enter into any contract, maybe business or otherwise, provided this during the peace time. There is no any war between these two countries. Suppose for the last so many years, A in country X, B in country Y, they are transacting or doing business, export or import business. But in the because subsequently war broke out between two countries, A will become, if war broke out between X and Y countries, A in X country, B in Y country become alien enemies. There should not be any further transactions or further contract between these. So contract between alien enemies is opposed to public policy. So this is the thing. So I have covered all the things in detail also. And the last one is criminal conspiracy. So section 120A and 120B of Indian Penal Code, which was inserted under Constitution under Criminal Law Amendment Act 1913, by Criminal Law Amendment Act 1913, Chapter 5A containing Section 120A and 120B were inserted to Indian Penal Code. According to that, any agreement entered into between two parties for an illegal act or legal act by illegal means, that that activity is called, that agreement is called criminal conspiracy. If two or more persons enter into an agreement to commit an illegal act or legal act by illegal means, that activity is called criminal conspiracy. Conspiracy means breathing together. It means breathing together means to breathe together, two heads must come together. Otherwise, without two heads come together, breathing cannot take place. Like that, to enter into any illegal agreement, two parties must be present. Otherwise, to constitute a criminal conspiracy, there must be two parties come together to enter into an agreement. If the agreement is to commit an illegal act, that is a criminal conspiracy. Legal act by illegal means, that is a criminal conspiracy. Okay, I will my son is, there is one seat, before my son there is another candidate. So you abduct that boy somewhere. We know some movies we are seeing, dance competition, sports competition, that hero is abducted by the villain to make his son number one. In so many movies are there. So that is why, suppose villain's son is number one, hero's son is number. So that is recently in Maharshi movie that situation came, and some other movie, Lakshya, one movie is there, that is also archery. That the situations came. So like this, that illegal means. So to make my son number one, my potential threat is another rival contestant. I engage somebody to abduct him and keep him somewhere so that he cannot attend the attend the interview or competition. That is criminal activity. That is criminal. So to commit an illegal act. So I think I will give you 5 lakhs. I'll give you the candidate who is in front of me, you delete him. That is illegal act. So doing a legal act, committing illegal act, or doing illegal act by doing legal act by illegal means, both are this thing. Getting job is good, but by giving bribe, getting job is illegal. So it is illegal to get to commit a commission of legal act by illegal means also illegal. So directly illegal or committing legal act by illegal means, both are both constitute. If that boy is regularly irregular, regular, both means he is not regular to college, he never come to college. Regularly irregular, irregularly regular, both are same. Same. Like that, committing an act by illegal means, I will give you 5 lakhs, you go and kill him. That is illegal act. Oh, this is. So the criminal conspiracy, section 120A of Indian Constitution speaks about criminal conspiracy. Section 120B, 2121A, 120A defines criminal conspiracy. If any agreement is entered into to commit an illegal act or legal act by illegal means, that is criminal conspiracy. They are called conspirators. 120A. 120B prescribes punishment. So here there is no any specific punishment prescribed. For all the offences punishable with life imprisonment, death sentence, and other offences which are punishable with 2 years rigorous imprisonment. For all, whatever activity, whatever criminal act the persons are engaged, that person is called abettor. Suppose I want to kill somebody, I don't do it, I engage some rowdy shooter to go and kill him. I will be called abettor. That rowdy shooter who is engaged to kill my enemy is called principal wrongdoer. Suppose that principal wrongdoer is caught by police and in interrogation he reveals my name. So and so Rao gave me 5 lakhs to kill him. Then for what offense he will get the same offense. So I am called abettor. The person who is engaged by abettor to commit a particular crime is called principal wrongdoer. When once his offense is ventilated, visualized, made known, whatever punishment is given to awarded to a principal wrongdoer, the same punishment is awarded to abettor also. So like this, it may be kidnapping or abduction, criminal conspiracy, theft, robbery, whatever it may be. What is the punishment for that particular offense? The same punishment will be given to principal wrongdoer and the abettor. So the concept of abettor explained in detail in Indian Penal Code. If you want, you can refer. So that is the. So these are the issues under which are opposed to public policy. Section 26, agreement in restraint of marriage. 27, in instrument in restraint of trade. 28, in agreement in restraint of legal proceeding. 29, agreement containing uncertain kind of points and not for certainty. 30, wagering agreement or betting agreement, and details of wagering agreement and next I will take up. So in addition to this, agreement with alien enemy is opposite to public policy, the object is void. Is similarly insolvent or bankrupt. last one is criminal conspiracy. These are over. So all the points I have already discussed in detail, but in more detail, one topic is to be explained in that is section 27. Here, now I want to discuss in detail 26 agreement in registry of marriage. In first I have already covered, because agreement means in marriage means all the points I have covered with reference to Pierce versus Catherine case also. 2,000 pounds reward. Next, the detailed information should be given. Now we as agreement in restraint of trade. Section 27 of the Indian Contract Act enunciates that among all the topics, agreement in restraint of trade is very important. Essay question may be asked in this, and other points, short notes may be asked. For short notes, wagering contract may be asked for short notes. This agreement in restraint of trade may be asked as essay question. What is agreement in restraint of trade? So, Section 27 of the Indian Contract Act tells that any agreement made violating the right to trade, profession or business, that is void. Any agreement entered into in restraint of trade is void. So, when two persons should not enter into an agreement in which one party should be prohibited from taking up any profession, because Article 19(1)(g) of Indian Constitution declares that right as a fundamental right. Every citizen in the country is conferred the right to take up any profession of his family profession, any business, any trade, which must be lawful. The nature of profession or business must be lawful. Nature of business or profession must be lawful. It must not be opposed to public policy. It must not be opposed to public policy. Then it is not only a defense protection given under Section 27 of the Indian Contract Act, but also fundamental right guaranteed under Section Article 19(1)(g) of the Indian Constitution. Now, coming to the law relating to agreement in restraint of trade was explained in detail and laid down by House of Lords in a leading case. That is Nordenfeld versus Maxim Nordenfeld Guns and Ammunition Company Limited, 1874. So the law relating to agreement in restraint of trade was clearly explained and laid down in Nordenfeld versus Maxim Nordenfeld Guns and Ammunition Company Limited. In this case, defendant Nordenfeld was a Swedish national. Defendant in this case, Nordenfeld was a Swedish national, the citizen of Sweden, and he has some business. Quick firing guns business. He sold his quick firing guns business to plaintiff company for 2,87,500 pounds. The defendant in this case was a proprietor of a business, quick firing guns company. He sold his company to plaintiff company for 2,87,500 pounds, which was a very, very big amount in those days. Now, while purchasing the business, the plaintiff company put two conditions. What conditions? Number one, up to 25 years, you should not start the same business anywhere. That is first condition. Second condition, you should not start any other business which will compete directly or indirectly to our business. That is the second condition. The court said, so far as the first condition is concerned, that you should not do the same business for a period of 25 years is correct, because they purchased it with a heavy amount. Second condition, you should not do any other business, any other professional activity that will directly or indirectly compete with this. It is wrong. So, the first condition, because any agreement which infringes, violates, curtails, takes away the fundamental right or right guaranteed under Section 27, that agreement is void. So that is the view given by the House of Lords in this case. So accordingly, first condition was allowed, second condition was declared valid. So the law relating to agreement in restraint of trade was laid down by the House of Lords in a leading case, Nordenfeld versus Nordenfeld versus Maxim Nordenfeld Guns and Ammunition Company Limited, 1874. This is the position. So like this, that is why when two parties enter into an agreement, the agreement should not contain, should not restrain any profession to be taken up, legitimate profession to be taken up by other party for his livelihood. One is absolutely free to take up his family profession or any trade, any business, any service, whatsoever it may be, which is lawful, which is not opposed to public policy. That is like that. This is over. So the agreement in restraint of trade is subject. There are some exceptions are there. 4 exceptions. What are these 4 exceptions? Exceptions means an agreement in restraint of trade is void. If any condition is put under agreement, if it opposes trade, it is void. But there are some cases in agreements in restraint of trade are not void but are valid. In some professions, in some cases, an agreement can be entered into between the parties for taking up, for imposing some restrictions. Now, number 1, goodwill. Number 1, goodwill. Goodwill is an intangible asset. It carries, it contains the name and fame of an individual or a company. Goodwill. So how reputation is goodwill to individuals. Goodwill is wealth to company. For example, one TV is there. It is some reputed company. If it is 30,000, people will comfortably purchase because of goodwill on that company. If better TV, better functioning TV available for 15,000 or 20,000, that company without a newly stranger company, the people will not purchase. Because depending upon the goodwill of that company, people are ready to pay double the price. So when suppose in the market there are 2 companies, number 1 and number 2. So number 2 wants to become number 1 in the market, and the number 2 company wants to purchase number 1 company, and so that number 2 will become number 1. So when once number 1 sold its business to number 2, then the number 2 will be number 1. In such case, subsequently number 1 company should not start another business with the same name. So that is the goodwill. When once 2 purchase the goodwill of 1, the 1 should not make use of the goodwill for starting another business. That is number 1. Number 2, next question is Partnership Act. Partnership, the ideal of partnership as one partner acts for all the partners, all partners act for one partner, one for all and all for one. So when a partnership is entered into under section under Indian Partnership Act 1932 lays down the rules relating to partnership. Suppose when 2 or more persons start business, up to 10 for banking business, other than banking business up to 20, minimum partners 22, maximum partner 10, 20 for other business, for banking business 10. So when 2 or more parties subject to 10 and 20 as the case may be start business, they should concentrate on the same business. Anyone, the number of partners may be 3, 4, 5, as the case may be. When the group of partners are doing the business for the firm, anyone should not do the same business outside. That is one rule. Secondly, if the partnership is not working well, if the partnership is not running well, and suppose if any partner wants to go out, outgoing partner, when once any partner, suppose 5 partners, 1 partner wants to go out taking his share, and when once he goes out for a particular period, he should not start the same business. Third one, though it is a freedom of right to trade. Last one is when the company is partnership is about to be dissolved. as per 13 class 2. When the partnership is to be dissolved, before suppose next year we are going to dissolve, but this year one partner should not go out and start the business. So like this, these are the rules for welfare and for partners and security, survival and existence of the partnership. Certain rules have been framed under the Partnership Act. They are strictly adhered to. The rule, if any, infringes fundamental right or envisaged by Section 27 of the Indian Contract Act, that is, that condition is not void, it is valid. That is second thing. Third one is trade combinations. Trade combinations. In business, there is unity of some traders. So suppose all traders must fix that, all builders fix that 2 BHK must not be less than this, 3 BHK must not be less than this. Like that, Xerox people say that one page 2 rupees only. Nobody should do for 150 or 1 rupee. There will be some trade combinations. Suppose any Xerox man thinks that if I ask 2 rupees, business is not good. If I do it for 1 rupee, business will be good. Instead of having no business for 2 rupee, let me have business for 1 rupee. I want to exercise my trade fundamental right to take up any trade of my choice. I should not say, because even though it is his fundamental right to do business at any time, he must not there be the agreement. When he is a member of the trade combination, he must strictly follow the rules and regulations of the union, and he should not go outside their direction. For that, some trade combinations and union of trade combination can impose certain restriction. If that restriction takes away the fundamental right, takes away the rule laid down under Section 27 of the Indian Contract Act, they cannot be rendered void, they will be valid. So this is another thing. Last one is service contracts. Service contract means, we are an employer may give attractive salary to one engineer or doctor or somebody, saying that you should do, suppose a doctor, number one cardiologist, you have to do serve in my hospital only. You should not do work in other hospitals. That may be the condition he may put. So if he gives attractive salary and attractive remuneration, and he can take agreement with that cardiologist, maybe doctor, maybe any dentist, or maybe any teacher, like in Andhra Pradesh, Telangana, there are some corporate colleges like Chaitanya Narayana. They pay salary to chemistry, physics, mathematics lecturers, botany, geology, MSET, G engineering, IIT, all. They are paying a heavy attractive salaries. Suppose the Chaitanya corporate college pays him some 3 lakhs to 5 lakhs salary, and he puts a condition that he should not work in Narayana or Bhashyam or any other college. That agreement, though it is in restraint of trade, it is valid. But however, as per Nordenfeld company case, second rule, so he should not do in local colleges or around, but he may be allowed to, he should not be constrained to go to Delhi or Bombay to address a seminar or any lecture for some remuneration. That should not be appropriate. So service contracts also are there. So in the beginning, I have covered 26. I have covered enough. 27 I did not cover. I have completed quickly. Some 28 agreement in restraint of law. In law, the enough portion I have completed. 29 uncertainty I have completed. 30 wager I completed for limited, and in detail the contract of wager 30 and contingent contract I will take one small class and explain in detail. With this chapter will be over. Thank you very much, dear friends, and for your kind cooperation. I am having a very good inclination to take up the lectures at the earliest, because in my lifetime, my ambition is to deliver lectures on all the 30 subjects. You can sincerely, honestly, I'm sincerely, honestly telling, you can confidently rely on my lectures to acquire good knowledge. So here in contracts, few more topics are there. So already I uploaded these lectures, but the revised lecturer will be certainly better. but whatever mistakes I committed there cannot be repeated. It will be absolutely, my second lecture will be an improvement over the first lecture. If you, I covered some certain points there here, so you can make use of both the lectures. So far I have covered in English almost all vital subjects which are available, which are prescribed for study in competitive exams, so judicial officers exam, CPC, CRPC, evidence, so IPC, administrative law, constitutional law, company law, all important vital subjects I have covered. The remaining subjects I have to cover. Today, after 3 classes, I will take up in English and Telugu. Next one is contingent contract and wagering contract in detail I will tell. It requires some half an hour lecture. And then next I will take discharge of contract. It is a big chapter. It requires one lecture. Quasi contract is one lecture. Remedies. So these topics I will cover. Immediately after covering completing these contracts one, I will proceed to constitutional law 2. In constitutional law 2, very few lectures I have given. I will have to cover amendment I covered, judicial review I covered, most important. Then independence of judiciary. Previously I taught in several places. And constitutional law, service matters, center-state relations, and other important topics. 2-3 lectures, hardly 3-4 lectures I will cover. Constitutional law 2, both English and Telugu I will cover. Next, I will take family law 2, succession and joint family, both in English. Whatever subjects I have not covered, I will teach both in English and Telugu. And Telugu, Indian Penal Code, I have delivered adequate number of lectures, but for the purpose of Telugu student, I will deliver them in Telugu IPC. If necessary, I will translate them into English also, because basically I have to provide first year 10 subjects both in Telugu and English for the convenience of Telugu students also. For the convenience of Telugu students, though I teach in Telugu, immediately I translate into English, but the previous lecture will 100% will be an improvement over the revised lecture. So the students of English media are suggested to follow both old lecture and new lecture. So I have covered a very good number of lectures. I have completed 195 lectures. This is by 196 lectures. So when once I will be able to complete 300 lectures, so almost 30 subjects will be completed. Actually, I wanted to start labor law, but labor law I started working also. But meanwhile, what happened, labor law courts have come. So I have to wait for the bills are there, the draft bills, and the new president is appointed, is elected recently. And after when the bills, pending bills on labor laws, labor codes are implemented, how they will come into force, what developments will have, will be brought about. Keeping in mind, I will take up labor law lectures. Some students are asking me to deliver lectures on labor law. Labor law, I will certainly, I am very, very eager to speak on labor law. And intellectual property also I have worked recently. I can comfortably teach intellectual property. Intellectual property is something, some subjects are there, moot court. The lectures are not that much necessary. Moot court is there, drafting, pleading is there, some subjects are there, but the main subjects are CPC, CRPC, evidence, IPC, constitutional law, administrative law, alternate dispute resolutions. These topics I have thoroughly explained. More than 12 classes I taught. Administrative law I gave number of classes. Administrative law I gave number of classes. Constitutional law I gave number of classes. All these things. What are the subjects that will appear, that are prescribed for study in competitive exams? I have covered thoroughly. So what all subjects, lectures I have delivered so far will be more than enough. The deficit is mainly constitutional law 2, few more topics. Family law 2, succession I did not cover. I think succession is not prescribed for competitive exams also, but it is a very good subject. It is a subject of great public importance. I must have to cover. Thank you very much for your patient hearing. Make use of my lectures. Only student career only you can attend the classes, and when once you go to court, you won't be able to have any time to learn any subject. Thank you very much. Thanks a lot.